In Canada, a lot of legal questions turn on whether someone has a reasonable expectation of privacy. But a lot of people think of privacy as being binary, an either or, but it's much more nuanced than that. In this discussion, I'm going to go over how reasonable expectation of privacy is complicated and involves more factors than you might think. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. You should check out the full disclaimer below, but you should know that I'm about to give you a high-level overview of a pretty complicated and nuanced subject. Any opinions expressed should not be attributed to my firm or any of its clients. In Canada, a lot of legal questions turn on whether someone has a reasonable expectation of privacy. But a lot of people think of privacy as being binary. You have privacy or you don't, but it's much more nuanced than that. You can be in a public place and still have an expectation of privacy. And in some circumstances, you can have a limited expectation of privacy with regard to, for example, your employer, but still have an expectation of privacy vis-a-vis the state. So where does this come up? One example is voyeurism. In Canada, voyeurism is a criminal offense, and one iteration of the offense requires a reasonable expectation of privacy. We also have wiretapping law, which requires that the intercepted conversation be private. Also, whether the police need to get a warrant in any particular case will often turn on whether there is a reasonable expectation of privacy. But how do you figure out what is private, or whether there is a reasonable expectation of privacy? One Supreme Court of Canada case that discusses this at length is the 2012 decision in R and Cole. But this case also led to a lot of confusion because of the difference between the employer and the police. In Cole, the accused was a high school teacher charged with possession of child pornography and unauthorized use of a computer. He was permitted to use his work-issued laptop for incidental personal purposes. While performing maintenance on the device, a school technician found a hidden folder containing nude and partially nude photographs of an underage female student. The technician, not surprisingly, told the principal and copied the photographs to a compact disc. The principal seized the laptop, and school board technicians copied the temporary internet files onto a second disc. The laptop and both discs were handed over to the police, who, without a warrant, reviewed their contents and then created a mirror image of the hard drive for forensic purposes. The question was whether the police needed to get a warrant to review the laptop once it had been handed to them. Remember, it was owned by the school board and was given to the police by the school board. The Canadian Charter of Rights and Freedoms requires that the police get a warrant or act under the authority of a reasonable law where they propose to search an item or a place where there is a reasonable expectation of privacy. In this case, the trial judge said that a warrant was required and excluded the evidence. The Summary Conviction Appeal Court reversed that decision, finding that there was no Section 8 breach. The Court of Appeal for Ontario then set aside the decision and excluded the disk containing the temporary internet files, the laptop, and the mirror image of its hard drive. Now, the disk containing the photographs of the student was found to be legally obtained and therefore admissible. As the trial judge had wrongly excluded this evidence, the Court of Appeal ordered a new trial. But when it got to the Supreme Court, that court found that he had an expectation of privacy in the contents of the laptop, at least vis-a-vis the police. But there is no question that what the school board did was lawful. The court found, consistent with previous cases, that computers used for personal purposes contain information that is meaningful, intimate, and touching on the user's biographical core. Canadians may therefore reasonably expect privacy in the information contained in these computers where personal use is permitted or reasonably expected. The fact that the school owned the computer was relevant, but not determinative. The court said workplace policies are also not determinative of a person's reasonable expectation of privacy, at least as far as the police are concerned. Whatever the policies state, the court said one must consider all of the circumstances in order to determine whether privacy is a reasonable expectation in that particular situation. While workplace policies and practices may diminish an individual's expectation of privacy in a work computer, they do not remove that expectation entirely. A reasonable, though diminished expectation of privacy is still a reasonable expectation of privacy, protected by Section 8 of the Canadian Charter of Rights and Freedoms. This means the state can only intrude upon that reasonable expectation of privacy under the authority of a reasonable law. So by searching the laptop without a warrant, they infringe the accused's rights under Section 8 of the Charter. The ownership of the laptop by the school board, the workplace policies and practices, and the technology in place in the school reduced the accused's privacy interests in the laptop, at least in comparison to a personal computer, but they did not eliminate it entirely. On balance, the totality of the circumstances support the objective reasonableness of the accused's subjective expectation of privacy. While the principal had a statutory duty to maintain a safe school environment, and by necessary implication, a reasonable power to seize and search a school board-issued laptop, the lawful authority of the accused's employer to seize and search the laptop did not give the police that same power. The school board was legally entitled to inform the police of its discovery of images on the laptop. This would doubtless have permitted the police to then go and obtain a warrant to search the computer. So in Cole, the accused did not have much of an expectation of privacy as far as his employer was concerned. Because of their policies, they could search the laptop they owned probably at any time, but the police can't. And the school board can't give permission to the police to search the laptop for information that is about the accused. So Cole tells us that expectation of privacy is a continuum going from very high to very low, but a low expectation of privacy is still an expectation of privacy as far as the state is concerned. And at the same time, you may have almost no expectation of privacy with regard to your employer, but enough of an expectation of privacy with regard to the police that they have to go get a warrant to look. Another interesting discussion of this question is a case called Jarvis. In Jarvis, the accused was a teacher at a high school. He used a camera concealed inside a pen to make surreptitious video recordings of female students while they were engaged in ordinary school-related activities in common areas of the school. Most of the videos focused on faces, upper bodies, and breasts of female students. The students were not aware that they were being recorded. Of course, they did not consent to the recordings. A school board policy in effect at the relevant time prohibited the type of conduct engaged in by the accused. So the accused was charged with voyeurism under Section 162(1)(c) of the Criminal Code. That offense is committed where a person surreptitiously observes or makes a visual recording of another person who is in circumstances that give rise to a reasonable expectation of privacy if the observation or recording is done for a sexual purpose. The case wound up in the Supreme Court of Canada on the question of whether there was a reasonable expectation of privacy in the classrooms and hallways of the school. It is worth noting that there were official surveillance cameras in the schools, including the hallways where Jarvis recorded students. But what Jarvis did, the court found, was very different. The court said, and I quote, "Given ordinary expectations regarding video surveillance in places such as schools, the students would have reasonably expected that they would be captured incidentally by security cameras in various locations at the school, and that this footage of them could be viewed or reviewed by authorized persons for purposes related to safety and the protection of property. It does not follow from this that they would have reasonably expected that they would also be recorded at close range by a hidden camera, let alone by a teacher for the teacher's purely private purposes," an issue to which I will return later in these reasons. In part due to the technology used to make them, the videos made by Mr. Jarvis are far more intrusive than casual observation, security, or camera surveillance, or other types of observation or recording that would reasonably be expected by people in most public places, and in particular by students in a school environment. So while the students should have expected to be observed by the school's cameras, that did not ultimately affect their expectation of privacy where a teacher with a hidden camera was concerned. The court said the question is whether, in the circumstances, would a person reasonably expect not to be the subject of the type of observation or recording that in fact occurred. The inquiry should take into account the entire context in which the specific observation or recording took place. The court said relevant considerations may include the location the person was in when she was observed or recorded. 2, the nature of the impugned conduct, whether it consisted of observation or recording. Awareness of or consent to potential observation or recording. 4, the manner in which the observation or recording was done. 5, the subject matter or content of the observation or recording. 6, any rules, regulations, or policies that governed the observation or recording in question. 7, the relationship between the person who was observed or recorded and the person who did the observing or recording. 8, the purposes for which the observation or recording was done. And 9, the personal attributes of the person who was observed or recorded. The court said this list of considerations is not exhaustive and will not be applicable in every case. Now, the court noted that privacy, as ordinarily understood, is not an all-or-nothing concept, and being in a public or semi-public space does not automatically negate all expectations of privacy with respect to observation or recording. Rather, whether observation or recording would generally be regarded as an invasion of privacy depends on a variety of factors, which can include the location, the form of the alleged invasion of privacy, the nature of the observation or recording, the activity in which a person is engaged when observed or recorded, and the part of the person's body that is the focus of the recording. Now, it's a cliche to say that you have no privacy, so get over it. Well, the Supreme Court of Canada hasn't gotten over it. While your privacy may be diminished in some cases and some places, it is far from dead. This passage from the court is important, in my view. In today's society, the ubiquity of visual recording technology and its use for a variety of purposes mean that individuals reasonably expect that they may be incidentally photographed or video recorded in many situations in day-to-day life. For example, individuals expect that they will be captured by video surveillance in certain locations, that they may be captured incidentally in the background of someone else's photograph or video, that they may be recorded as part of a cityscape, or that they may be recorded by the news media at the scene of a developing news story. In the school context, a student would expect that she might be captured incidentally in the background of another student's video, photographed by the yearbook photographer in a class setting, or videotaped by a teammate's parent while playing on the rugby team. That being said, individuals going about their day-to-day activities, whether attending school, going to work, taking public transit, or engaging in leisure pursuits, also reasonably expect not to be the subject of targeted recording focused on their intimate body parts, whether they are clothed or unclothed, without their consent. A student attending class, walking down a school hallway, or speaking to her teacher certainly expects that she will not be singled out by the teacher and made the object of a secretive minutes-long recording or series of recordings focusing on her body. The explicit focus of the videos on the bodies of the students recorded, including their breasts, leaves me no doubt that the videos were made in violation of the students' reasonable expectations of privacy. Indeed, given the content of the videos recorded by Mr. Jarvis and the fact that they were recorded without the students' consent, I would likely have reached the same conclusion if they had been made by a stranger on a public street rather than by a teacher at school in breach of a school policy. Going through life, you may expect that you'll be observed by others as you pass them on the sidewalk. You may expect that security cameras may be set up on private or public property for lawful purposes. Just because of those facts, your privacy is not eradicated. It may be calibrated. And whether someone violates your reasonable expectation of privacy is very circumstance specific. It will look at the place, the time, the technology, who is doing it, and why. It may be reasonable to be observed, for example, but not reasonable to be recorded. This question can arise in a bunch of other circumstances, for example, where someone sues someone else for invasion of privacy, whether the plaintiff had a reasonable expectation of privacy at the time, and in those circumstances will be germane. We also have criminal and civil laws related to the non-consensual distribution of intimate images that also require a reasonable expectation of privacy. In those cases, one may fully expect that the recording is made for the personal purposes of the participants, but there is an expectation of privacy with respect to strangers. So at least in Canada, the statement that privacy is dead or that you have no expectation of privacy is just plain wrong. I hope that this has been interesting and useful. I try to put out a new video each week, so if you're interested in this sort of content, please click the like and subscribe buttons. Also leave a comment if you have any questions or if you have any suggestions for another topic to cover. And of course, feel free to share this with anyone who you think may be interested in Canadian tech and privacy law. Thanks for tuning in.